I guess we are there. Right, we are live, I believe. Good morning, everyone. Thank you for joining us today. We are proud to present to you the second season of the Lawyers Wed lecture series. Today's webinar is brought to you in collaboration with the virtual lawyer and the latest laws. Over the course of this month, we would be conducting a number of webinars on all the relevant topics of law. I hope we don't forget any of them. Each topic is equally important. I'm proud to present you on our second webinar today. We had another one in the morning today. Once again, a very warm welcome. Now I would like to give the podium to Ms. Kopin Kandhari. Over to you, ma'am.
Good evening, everyone. Especially to all the dedicated participants here who are on Sunday studying or finding out more about the IBC. So here I go. There's a small brief on the IBC before we go into the detail. It basically consolidates the insolvency laws for various entities under a single legislation. It is equally applicable to companies, limited liability partnership firm, and partnership firms and individuals. This code empowers financial and operational creditors to realize their debts by making the CIRP time-bound, rather than dwelling for years to realize the same from a corporate debtor, and thus also gives them the freedom to lend money to Indian entrepreneurs with ease. Insolvency of a company is most often shown by the inability of a company to pay those who owe its money to when the payments are due. Winding up a company deals with ending business affairs and terminating company obligations. Liquidation is often considered as a last resort after attempting other insolvency procedures. The foremost objective of this code is reorganization, that is resolution, entailing taking over of the corporate debtor as a running concern. Now, recently, 2018 proved to be a constitutional litmus test for the Insolvency and Bankruptcy Code 2016, with 10 writ petitions and one special leave petition assailing the constitutional validity of the code. Various matters were brought into question, and on January 25th, 2019, a judgment was pronounced by the Supreme Court on this batch of petitions in Swiss Ribbons Private Limited and another versus Union of India. That concluded with, the Insolvency Code is a legislation which deals with economic matters and in the larger sense deals with the economy of the country as a whole. Earlier experiments, as we have seen, in terms of legislations have failed. Trial having led to repeated errors ultimately led to the enactment of this code. Now, I'll invite Advocate Tarveen Singh Anand to brief us about a keynote speaker who will enlighten us on IBC in detail, the amendments in IBC and its relevancy and complexities in the current scenario. Over to you, Tarveen.
Good evening, everyone. Thank you for being here on this wonderful evening. Today, we are pleased to welcome our keynote speaker, Senior Advocate Mr. Neeraj Malhotra, for this webinar. Mr. Neeraj Malhotra is a Senior Advocate, having been designated so by the Honorable Delhi High Court in the year 2017. Mr. Malhotra is an alumni of Delhi Public School, R.K. Puram, having been passed out from the school in the year 1986. He had opted out for the commerce stream in his school and consequently went for the BCom Honours course from Delhi University. After securing his bachelor's degree in commerce in the year 1989, he went on to do his bachelor's in law from Delhi University and was awarded his bachelor's degree in law in the year 1992. Mr. Malhotra thereafter joined the chamber of a prominent advocate in Delhi as an associate, and under his tutelage and guidance dealt with various branches of law and appeared in multifarious courts and tribunals. Mr. Malhotra later formed a partnership firm in the year 1998 and thereafter started his individual practice in the year 2008 before being designated as a senior advocate. Mr. Malhotra has 28 years of experience of practice and he specializes in the field of commercial and insolvency laws, besides the capital and commodity market laws. He appears regularly before NCLT and NCLAT and has rendered numerous legal opinions under the Companies Act and the IBC. Mr. Malhotra has been invited to the National Judicial Academy in Bhopal on more than one occasion and has addressed sitting High Court judges on commercial laws and security market related laws. He is an avid writer and spends a lot of time in mentoring young and aspiring lawyers. And today, he will be sharing his knowledge and wisdom on the relaxations and amendments in the IBC framework. With that, I would request you to give your full attention to Sir and help me in welcoming Sir for the webinar. Over to you, Mr. Sir, Mr. Neeraj Malhotra, sir.
Thank you, Tarveen. Thank you for that introduction. And thank you for having me here on this webinar. It's a pleasure to be here.
Our pleasure.
Special thanks to Mr. Mudgul, who had requested me to speak on this topic. And it's really a pleasure being here. So, just taking forward what Poplin had stated in the beginning, the Insolvency and Bankruptcy Code basically consists of, I would say, 4 stages. The first stage is resolution, where you attempt to resolve the crisis going on in a corporate debtor company and frame a resolution plan under a corporate insolvency resolution process and try to take over the management of the company as a running concern. The second stage is where, assuming where the resolution process doesn't go through, then the Supreme Court and the NCLT has now carved out an exception where it says that even you can go in for a settlement under Section 230 of the Companies Act 2013 and try to enter into a negotiated settlement which will save the company from liquidation. So the Supreme Court, in the case of Swiss Ribbons, Poplin was mentioning this, the relevant judgment at the very beginning. So Swiss Ribbons has said that settlement or prior to liquidation is also provided there under the Act, and that can also be undertaken before the liquidation actually takes place, in case the resolution process falls. And there have been instances where the appellate authority, that is the NCLAT, has permitted a period of almost 90 days for the parties to arrive at a settlement, invoking the provisions of Section 230 of the Companies Act 2013 before the liquidation takes place. And in case the settlement is not able to go through under Section 230, then the third stage of liquidation flows and follows. So like Poplin was mentioning at the very beginning, liquidation is the last resort which is undertaken under the IBC. The scheme of the code, Insolvency and Bankruptcy Code, is also to put the liquidation of the corporate debtor as a final resort when a resolution cannot be arrived at or when a settlement cannot be arrived at. So the third stage would be the liquidation of the company, of the corporate debtor, where again the company, the corporate debtor can be sold as a going concern, or the assets of the corporate debtor or the company in the liquidation can be sold and then distributed amongst the creditors, the financial creditors and the operational creditors and the other statutory dues of the company, the wages, etc. And the fourth stage is post liquidation, the dissolution of the corporate debtor happening. So essentially, there are 4 stages under the IBC: resolution, settlement, liquidation, and dissolution. That is how the scheme of the Act is. Now, moving down to the aspect of today's webinar, the recent amendments which have taken place under the Insolvency and Bankruptcy Code, and also the relaxations provided on account of the COVID-19 situation, which has now which cropped up in the country almost since February and March. So I will quickly run through this. There are a lot of amendments, but I wouldn't really like to dwell upon all of them. I would just refer to the relevant material amendments and how these amendments and how these relaxations have aided in the carrying out of the purpose of the IBC. So first, let me just come to the relaxations which have been granted by the courts, essentially post COVID-19. Let me start with that, because although this would be, I'm sure, to everybody's knowledge, but nonetheless, let me just quickly run through them. Now, the Supreme Court, the first order of the Supreme Court is of 23rd March 20, wherein a suo motu writ petition, the Supreme Court on 23rd of March 2020 took note of the pandemic which had created havoc in the country, and fixed the date of 15th March 2020, from which date the limitation would stop running in respect of all the suits or appeals or all proceedings which are to be filed in the court. And this relaxation in the limitation period was to continue till further orders, till such time the lockdown was lifted. So it was a general order passed by the Supreme Court, exercising its powers under Article 141 of the Constitution of India, wherein it extended the period of limitation from 15th March onwards till further order. And in the subsequent order of the Supreme Court, in the same proceedings, it was clarified to even include the provisions of the Arbitration and Conciliation Act to the extent of the time which was granted to the arbitrators for passing of the awards, and also to the Negotiable Instruments Act for filing of complaints under 138. So this was the first order which came to be passed by the Apex Court and extending the period of limitation. And the second order in the context of IBC was passed by the Appellate Tribunal, that is the NCLAT, on 30th of March 2020. Now, with that order of 30th of March 2020, the period contemplated for completion of the corporate insolvency resolution process under Section 12 of the IBC was also extended to the effect that the period post the lockdown, from the date of starting of the lockdown till further orders, that period was also extended, especially taking into consideration Section 12 of the IBC for completion of the insolvency, corporate insolvency resolution process. And second part of the order which NCLAT granted was that all interim orders which have been passed would continue till further orders. So these are the two orders which have been passed by the Supreme Court and the NCLAT. essentially covering the provisions of the IBC, wherein these relaxations in terms of limitation for filing petitions, appeals, etc., everything under all acts was granted. And NCLAT's order specifically stating that the time prescribed for completion of the corporate insolvency resolution process under Section 12 would be extended. Now, pre-amendment, the time provided for completion of the CIRP process was 180 days from the date of admission or the commencement of the CIRP process. So from the date of the admission of the application under Section 9 or under Section 7, the period provided was 180 days, extendable up to a further period of 90 days, which was subsequently amended to another period of 60 days, and thereafter finally to 330 days and a further period of 90 days in terms of the relevant amendment under Section 12, which I'll deal with it subsequently. So these are essentially the relaxations which have been granted by the judicial authorities on two fronts pertaining to the limitation aspect of filing petitions, suits, appeals, applications, etc., and the order of the NCLAT providing for extension of the time for completion of the corporate insolvency resolution process under Section 12.
So I have a little query on this. So are there any judgments covering or dealing with the aspect of applicability of Limitation Act to IBC? Like if a creditor has to file an application under Section 7 or 9, what will be the limitation period and from when it will start? That's a query, Aman.
Well, the issue of the applicability of the Limitation Act was settled by the Supreme Court in the case of BK Educational Services. Now, BK Educational Services, the judgment of the Apex Court in 2018, it categorically held that since an application filed under Section 7 and Section 9 are both applications, therefore, the limitation period will fall under the residuary clause or residuary article of the Limitation Act, which will be Article 137. So, Article 137 prescribes a period of 3 years from the date when the cause of action arises. So, the Supreme Court, in the case of BK Educational Services, has categorically held that the period of limitation for filing an application under Section 7 or Section 9, that is by the financial creditor or by the operational creditor respectively, would be 3 years from the date the default takes place. And default under Section 2, subclause 12 takes place when the amount of debt is due, becomes due and is not paid. So irrespective of the fact as to when the IBC was promulgated, when it came into effect, when it was notified, the period of 3 years will be taken from the date when the default occurs. That is when the debt became due and payable and when it was not paid. Now recently I recollect there was a recent judgment, I think last month, by the Supreme Court in the case of, I think, Babulal Gurjar, which took into consideration the judgment of BK Educational Services, because BK Educational Services actually laid down the law on the limitation. I think it's Justice Nariman's judgment, a very beautifully authored judgment. Babulal Gurjar also referred to this, the judgment of BK Educational Services in the peculiar facts of a case, and it also held that a period of 3 years would be the limitation period under Article 137, which would be taken into consideration for the purposes of filing a Section 7 or a Section 9 application. One thing I would like to point out, consider a situation where as on the date of the filing of an application, the 3-year period is over. Let us say you intend to, let's take a hypothetical case where I want to file a Section 7 or a Section 9 today, let's say on 1st of September 2020. But my default has occurred, let's say, on 1st of January 2016. So I am beyond the period of 3 years. I should have filed it by 2019, 31st of December. So what is the scenario? Am I remediless in this case or not? So there is one paragraph which I would like all my viewers to read in DK Educational Services. And I will just tell you what is the para number, because that paragraph or that portion of the judgment, which is at the end of the judgment pen down, says that because Section 7 and Section 9 both are applications, therefore Section 5 of the Limitation Act will also apply. So this, you see, it's a very interesting piece of, I would say, it is something between an arbiter and a ratio which has been laid down, but it has given a window to the operational creditors and the financial creditors to file an application under Section 5 of the Limitation Act seeking condonation of delay, because it is an application. And Section 5 applies, of the Limitation Act will apply. It applies to applications and appeals. So they have given a window, the Supreme Court says, Section 5 you can invoke. If you grant and if you show sufficient reasons and causes for not having filed this application within a period of 3 years, the NCLT can even condone it. So this is very relevant. So I would like all of you and all the viewers, especially the young colleagues who are viewing this, to please read the last paragraph of the judgment in DK Educational Services. And that para would be, I think, para number 40. Just let me tell you what the para number is. I think para number 27. So this is something which is very, very interesting. A window has been given. You might be hit by limitation, but you can file a Section 5 application seeking condonation. Obviously, it would depend upon case to case. If your delay is for more than, let's say, 2 years, 3 years, 4 years, then a different view may be taken. If your delay is, let's say, for 3 months, 4 months, because there could be cases where the delay is very trivial, a minuscule delay. So in that case, you can invoke Section 5. So law has been settled by the Apex Court. Article 137 will apply. The limitation period is 3 years. Section 7 and the Section 9 are, which is being filed as an application. Section 5 can apply. And one can file an application seeking condonation. So these are the two relevant judgments. I would say DK Education Services is the law of the land, which actually lays down this proposition of law. And it says that the coming into effect of the IBC in 2016 would not matter. Therefore, you cannot say that because it came into effect on 2016, my limitation will start only from 2016 onwards and not from 2014 or 15 if your default has taken place prior to that, because that has been laid down very clearly that no, coming into effect of this act of the IBC promulgation will have no effect in 2016. It will relate back to the period when the default has occurred. So
thank you so much, sir. Thank you so much.
So this is the the two judicial orders which have excluded the period of limitation, rather extended the period of limitation up to the date of the lifting of the lockdown. And now let me come to the first relevant amendment, which is of 5th of August 2019, brought into effect with effect from 6th of August 2019, video notification. Now this amendment in effect refers to two material provisions of the IBC, which is section 12 and section 30 subclause 2. Now, section 12, where this notification was amended. Like I told you, initially the period for completion of the corporate insolvency resolution process when the act came into being was taken as 180 days. And besides 180 days, a further period of 90 days was given in case the circumstances so desired. So taking it to 180 plus 90 days, which is 270 days. Now, there were instances where litigations were filed. Because it's a new act. It was a new act in 2016. So there was plenty of litigation in the matters which were taken before the NCLT. They went on to the NCLAT, then they went to the Supreme Court. So valuable time was lost during this period of litigation, as a result of which the insolvency process could not be determined and completed within the time period of even 180 days with an extended period of 90 days, so 270 days. And if the period, if the resolution process is not completed and the resolution plan is not submitted within that period, then obviously the company has to go into liquidation under the act. So taking note of all these pending litigations and the fact that the CIRP the process could not be completed within the time stipulated, especially in regard to the pending litigations which were going on and they were taking so much of time to get completed. This amendment was brought out, which extended the period of completion of the CIRP, that is the corporate insolvency resolution process, to 330 days in the first instance. And this 330 days also included the period which was spent by the parties in litigation. So section 12 was then amended, 330 days was put in, and besides this 330 days, a further period of 90 days was also given in case the circumstances so desired. The period of 330 days would be further extended by another 90 days, then depending upon the situation or the facts of a particular matter. If the circumstances so desired, it could be extended. The second material amendment through this, because there were quite a bit of amendments here, but the second material amendment which took place, we did this second amendment of 5th August notified on 6th August was that in terms of section 32, 30 subclause 2, there was a minimum amount which was fixed, which would be paid to the operational creditors in case of liquidation, and also the minimum amount which would be paid to the dissenting financial creditors. So we did this amendment while amending section 30 subclause 2, basically what the amendment did was it prescribed a minimum amount of a minimum payment, a minimum amount of dues to be paid to the operational creditors as well as to the dissenting financial creditors, in contradiction with the earlier provisions of section 30 subclause 2, which were notified when the act was promulgated. So I must also point out that these amendments were also challenged before the Supreme Court. The validity of the vires of these amendments which were affected, especially section 12 and section 30 subclause 2, were also challenged before the Supreme Court. And this is the famous case of SR Steels, where SR Steels was finally taken over. The management was taken over by ArcelorMittal. So this is that case where the vires were challenged before the Supreme Court. And the Supreme Court, in relation to both section 12, which was amended, and section 30 subclause 2, which was also amended with this amendment, had upheld the amendment of both these provisions. And the reason behind upholding, the primary reason behind upholding these two amendments was that as regards section 12, the court said that no doubt the process has to be completed in a time-bound manner. But since the period of litigation has also been included in the 330 period days, and the extension of 90 days is at the discretion. Therefore, there is nothing wrong as regards this amendment of section 12. When it comes to section 30 subclause 2, again, the Supreme Court said that it is in the wisdom of the committee of creditors how they are going to pay and what they are going to pay. So this section, the amended section 32, only prescribes a minimum limit. So that is basically beneficial both to the operational creditors as well as the dissenting financial creditors. So nothing has been taken away. Rather, a minimum criteria of payment is being fixed. So therefore, the Supreme Court, in the case of Committee of Creditors, which is a second judgment, in the case of SR Steel versus Satish Gupta, upheld the vires of this amendment and said that both the amendments of under section 12 and under section 32 are valid. So now, Tarveen, going ahead with the third amendment. Now, the third amendment is in relation to the personal guarantors of the corporate debtors. Now, section 60 subclause 2, which is contained in part 2 of the IBC. Part 2 pertains to the corporate debtors and part 3 pertains to the partnership firms and individuals. So section 60 subclause 2, which is contemplated, which is provided in part 2 of the IBC, talks about the corporate insolvency resolution process against the corporate debtors and its personal guarantors. So under the Act, under section 60 subclause 2, there was a mention of the proceedings against the corporate debtor and the personal guarantors being initiated. However, there were no rules and there were no regulations contemplated under the IBC wherein a financial creditor could proceed against a personal guarantor of a cooperative. So take the hypothetical case of a corporate guarantor of a company being there, and the company taking a loan from a financial creditor, and the a director or the chairman or any other person giving his personal guarantee to the financial creditor to secure that loan which has been taken by the cooperative. So there was this provision under the Act, but there were no rules, there were no regulations, there were no rules which were framed as to how you would proceed against the personal guarantor in case of a default of a debt arising by the cooperative. So on 1st of December 2019, the relevant rules and the relevant regulations pertaining to the filing of application before the adjudicating authority, pertaining to the bankruptcy process of a personal guarantor, and pertaining to the proceedings, which is the corporate insolvency resolution proceedings against the personal guarantor of a corporate debtor, came into being. So these rules and regulations lay down the entire procedure as to how a financial creditor would proceed against the personal guarantor of a corporate debt. So this was a material amendment, I would say, which was brought about in relation to the personal guarantors of corporate debtors being roped in and legal proceedings being initiated against them. Now, I would like to point out one thing. You must have seen recently the case where the State Bank of India initiated proceedings against the personal guarantor of Reliance, Anil Ambani. So those proceedings were initiated before the NCLT in Mumbai, and those proceedings were initiated taking recourse to Section 60 subclause 2, read with Section 95 and 97 of the IBC, along with these rules and regulations. I think this was the first major case where a financial creditor invoked the provisions of the IBC against a personal guarantor of a corporate debtor and initiated proceedings, which were somehow anyway later they were brought on to the Delhi High Court, and Delhi High Court stayed the proceedings against the personal guarantor. But what I want to say is that this was also one of the material amendments which were brought about, rather I would say, where the rules and regulations were framed and notified pertaining to the personal guarantors of the corporate debtors. So this was the second major amendment which was brought about.
So there's another query. Can two proceedings run simultaneously against the corporate debtor and personal guarantor also or not? If so, in which forums? And how does the law deal with this?
See, now the Supreme Court has dealt with this proposition of law in the case of State Bank of India versus V. Ramakrishnan. And what it has finally held is, because there was a conflict of views earlier also, but I would say, as I read it, that this judgment categorically clears the issue wherein it says that simultaneous proceedings can be brought against the personal guarantor of a corporate debtor in the NCLT itself. So there are two issues which this judgment has dealt. First is that if the proceedings are already initiated and are going on before another forum, let's say the DRT or under the SARFAESI Act, they can be transferred here before the NCLT, where the proceedings, let's say under Section 7, are going on against the corporate debtor. So because you are the personal guarantor of the corporate debtor, proceedings can be transferred from that particular forum before the NCLT. The second situation which this judgment envisages is that in case no proceedings have been initiated. So this was a case where the proceedings had already been initiated against the personal guarantor. The second situation which this judgment envisages is a situation where you have not initiated any proceedings against the personal guarantor. So you can initiate those proceedings before the NCLT itself, along with the proceedings which are already going on before the NCLT against the corporate debtor. But obviously there would be a situation where if the proceedings are admitted against the corporate debtor, then the subsequent proceedings initiated by against the personal guarantor would have to be kept on hold. But yes, simultaneous proceedings can be initiated because the Supreme Court says it's better that all these proceedings before against these two persons, one is the corporate debtor and one is the personal guarantor, come before the same forum. Instead of going on in separate forums, resulting into possibly a conflict of judgments possible. So therefore get them before the same forum. So the attempt here is basically to consolidate the two proceedings, bring them before the same forum. And this judgment deals with that issue.
Thank you, sir.
So I would request the viewers, in case they want to look into this, it's by the name of SBI versus V. Ramakrishna. It's by the Supreme Court. It's 2018. So this was a second amendment, primarily where the rules and regulations were brought in. So I would say it's a major development. It entailed a quicker settlement of the disputes with the financial creditor. Because once you get the personal guarantors roped into the litigation, then it entailed a quicker and faster possibility of a settlement of the disputes and recovery of the loans, of the debt which is due and paid. So this was the second major amendment which took place by way of setting forth the rules and the regulations pertaining to the personal guarantors. Now the third amendment I would like to deal with is of 13th of March 2020, which was preceded by an ordinance in 2019. Now, this amendment of 13th of March 2020, which basically repealed the earlier ordinance of 2019, firstly dealt with the amendment in Section 7. And I think this would be to everybody's knowledge, that the allottees of a real estate were brought into the provisions of Section 7 of the IBC. If you recollect, there was a lot of controversy surrounding this fact, whether the home buyers, or as you call them in legal terminology, the allottees of a real estate project, they could be called as financial creditors or not. Just like there is an issue of the financial service providers not being part of the financial creditors. So Section 7 brought the allottees of the real estate project into the domain and purview of financial creditors, wherein there was a minimum stipulation provided that at least 10% of the total allottees of a real estate project or 100 allottees of a real estate project must come together and file an application under Section 7 in respect of that, the builder in respect of that particular real estate project. Now, this 10% and this 100 members is somewhat, if you would recollect, on the lines of the provisions which were there under the 1956 Companies Act pertaining to operation and mismanagement, where also you require 10% of the shareholders or minimum 100 shareholders. So this is one important development which got the allottees of the real estate project of a real estate into the domain and into the within the purview of Section 7 of the IBC, which pertain to the financial creditors, which obviously gave a lot of strength to the home buyers. And we have seen, if you look at the data, that substantial number of disputes with the builders have been sorted out in terms of whatever applications were being filed under Section 7 by these home buyers. And recoveries have been affected, although it's a provision. The IBC provides for a resolution of the disputes, but this was a case here. You have seen that recoveries were actually affected by the allottees, and things were settled. So one of the important amendments which has led to the recovery of monies from the market from these builders. The second amendment which took place, the second section which was amended was Section 14, if I am correct. So Section 14 was also amended, which pertains to moratorium. Now, we did this amendment of 13th of March 2020. This amendment contemplated that during the period of moratorium, if any licenses, if any permits, if any quotas, whatever they have been granted to the corporate debtor, they shall not be cancelled. So long as the corporate debtor has paid all the dues, etc., so that they shall not be cancelled. The purpose of this amendment was primarily to ensure that even if the resolution professional, or before that the insolvency resolution professional, before the COC sat, took over the management of the company, it should be taken and it should be kept going as a running concern. Similarly, it also provided, Section 4, the government also provided, that if there were goods and services being supplied to the corporate debtor, the supply of those goods and services should also not be jettisoned, or it should not be stopped. Again, the purpose was to ensure that when the IRP took over the corporate debtor, it was to be kept going as a running concern. So these were the two primary amendments which were carried out on 13th of March 2020. And another major amendment which took place here was in terms of Section 32A. Now, 32A was again a very interesting amendment, which stated that in case the management of corporate debtor is taken over in pursuance of a resolution plan, successful resolution plan, then any existing offenses against the corporate debtor would be obliterated, in the sense that the new management which is coming in and taking over the corporate debtor will not be saddled with any previous offense for which the company has been booked, the corporate debtor has been booked. Now, there are offenses where there is punishment and there is fine. There are offenses all across the Companies Act and other statutes where the contemplation of fine is there. That obviously is being put onto the company, where the company is also an accused. So this amendment in section 32A paved way for the new management to take over the corporate debtor as a running concern, minus all the offenses for which the corporate debtor had been. So these are the three major amendments in the section which were carried out by this 13th March 2020 amendment, section 7, section 14, and section 32A. Again, a very interesting piece of amendment. Like I said, Tarveen, it is a new code.
Yes, sir.
So where different laws have been consolidated into one, and I would say that it's almost a flawless crafted code. But as and when the situation demands, as and when new cases crop up, as and when new issues spring up, amendments are required. And the Insolvency and the Bankruptcy Board of India, IBBI, I would say, is quite it acts with alacrity, and it has been putting up these issues, considering these issues, and then doing whatever is required to ensure that the process or the scheme of the IBC goes on smoothly, incorporating all the required changes or amendments which are required. So I would say the number of amendments which we have seen is conspicuous and manifest of the fact that the board is conspicuous of these amendments which are required. It's taking cue and it's taking note of the developments which are taking place in the market. It's even taking note of the practical situations, of the practical difficulties being faced. So and overall, I would say there's been a rejig of the provisions of the code to quite an extent. Now, the next relevant amendment is of 24th of March 2020.
So just before that, so I would like to ask, are there any judicial pronouncement on the interpretation of the above section by NCLT or NCLAT? I think it would be beneficial for all the young lawyers who are watching.
Under what provisions?
So under the sections you have just mentioned, the amendments you have just mentioned.
714, 32A, I would say that there is no, per se, there is no judgment which would be material, in the sense that there are judgments, but nothing where it concerns the challenge or the viries, etc. There is nothing really pertinent which would come.
Right, sir. Right, sir.
Because issues were raised up, I would say under Section 7. Section 7, there was some litigation which was initiated pertaining to these home buyers, before the NCLT, where the issue which was raised is that this prerequisite of 10% or 100 allottees. What would be the situation in respect of these amendments where the petitions have already been filed? You see, I told you about the prerequisites which were included in the amendment to Section 7 in case of home buyers, that allottees of a real estate project were included in the definition of financial creditors. And there were two riders to it. One is that either you are, the application is by 10% of the allottees of the real estate project, or by a minimum of 100 allottees of that project. Now, the issue which cropped up in one of the litigations, I'm thankful to you, Taveen, for having put that, which is one litigation is pending, that what will it be, prospective or retrospective? What would be the situation of the applications which have been filed by the home buyers, which are pending, and now this amendment has been brought in? Would they still need to undo that and amend their petitions or not? You know, there could be a situation, you know, a lot of cases where you would have appeared where where only one allottee has filed a Section 7 application. When this whole issue was pending in the Supreme Court, whether the allottees can be called as financial creditors or not. So this issue, I believe, is still pending before the appellate authority as to whether this is prospective or retrospective, whether the applications are already filed by the home buyers or the allottees, whether they would need to amend these applications or not. So that is one area which is, I think, still under consideration as far as Section 7 is concerned. Now, 24th of March amendment I was talking about, which is the next relevant amendment, which amended Section 4 of the IBC, raising the threshold limit for initiation of the corporate insolvency resolution process from 1 lakh to 1 crore. Now, if you would see, the date is very relevant. This also came into the time when the COVID-19 pandemic had begun. So apparently the attempt and the reason, the rationale behind this amendment for raising the threshold limit from 1 lakh to 1 crore was to protect the under the micro, small and medium enterprises, the micro enterprises. Because as per the existing definition then of micro enterprises under the MSME Act, the criteria was the investment which had to be in manufacturing sector and the services sector, which was less than 1 crore. So apparently, although the amendment of 24th March is silent on this aspect, apparently the rationale to get this amendment into effect and to increase the threshold limit was to protect the micro sectors from taking the hit under the IBC. Although I believe from July of this year, the threshold limit of all the micro sectors, the medium and the small sectors have been increased. So the effect was to cushion and protect the micro sectors from being dragged into this proceedings under the IBC, especially in view of the COVID-19 situation, taking note of the fact that they would not be able to, repay their debts, and therefore they would necessarily be defaults in repayment of debts by the micro enterprise. So that was the intent when it was the amendment was brought in on 24th of March 2020. Now, the last amendment which I'm going to talk which is very talked about, is the insertion of section 10A. By the 5th June 2020 notification, and within section 10A, initiation of insolvency proceedings stands suspended with effect from 25th of March 2020 for a period of 6 months. Now, just let me read these provisions, because there seems to be an anomaly between the preamble and the main section. So, if you see this amendment ordinance, the preamble at one part says that, and whereas it is difficult to find adequate number of resolution applicants to rescue the corporate persons who may default in discharge of their debt obligations. Then it says, whereas it is considered expedient to suspend under section 7, 9 and 10 of the Insolvency and Bankruptcy Code to prevent corporate persons which are experiencing distress on account of the unprecedented situation from being pushed into insolvency proceedings under the said code for some time. Now, this is very relevant. The preamble here talks about two things. One is that the corporate persons, which includes corporate debtors, they are experiencing difficulties in repayment of their debts. Second, it says that some measures are required for some time. Now, if you thereafter go to section 10A, 10A says that notwithstanding anything contained in section 7, 9 and 10, no application for initiation of corporate insolvency resolution process of a corporate debtor shall be filed for any default arising on or after 25th of March 2020 for a period of 6 months or such for further period not exceeding 1 year from such date as may be notified in this bill. So this contemplates that no application for initiation of CIRP shall be filed. Prospective shall be filed for any default arising on or after 25th of March. So the default should have occurred on 25th of March or thereafter. That is, the non-payment of the debt should have been on 25th March or after 25th of March. That is, the debt should have become due on 25th March or after 25th of March. And if the debt has become due, that is, the default has occurred after 25th of March, you cannot initiate corporate insolvency resolution proceedings. Now, in the preamble, it says for some time, but the proviso says, provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. So now the anomaly which I see here is this suspension for a particular period of time in terms of the preamble, or is the suspension forever, as is there in the proviso to section 10? That is one. Number two, the preamble says it is to prevent corporate persons from being pushed into insolvency who are experiencing distress on account of the situation of the pandemic. What about the corporate persons or the corporate debtors who are not experiencing any problem on account of the COVID-19? So they would also be covered. So there is an anomaly between the preamble and the section. And also one issue which also had cropped up is, since this amendment has been brought into effect on 5th of June 2020, and the period of default which is mentioned that you will not initiate any corporate insolvency resolution process after 25th of March 2020, which is the date which you should take for the purposes of determining that you cannot file a corporate insolvency resolution process. Will you take the date as 25th of March as is specified here, or will you take the date of 5th of June, which is the date of this amendment? Tarveen, am I clear?
Yes, sir. Yes, sir.
So this was an issue which had also cropped up, and this was taken in before the NCLT Chennai in the case of Siemens versus Ramesh Kanyal. So this is today, after this amendment of 5th of June 2020, after this ordinance was brought into force. Apparently, this is the only judgment which has been rendered by the Chennai bench of NCLT. And Chennai bench of NCLT says that this ordinance will have a retrospective operation, in the sense that the date of default will be taken as 25th of March, irrespective of the fact whether the ordinance was promulgated on 5th of June, the date of default will be taken as 25th of March 2020. And if your default has occurred post 25th of March 2020, that is, your debt became due after 25th of March 2020, you will not be able to initiate any proceedings under section 7, 9 and 10 under the IBC. You will have the remedy elsewhere. You can file a civil suit for recovery, you can go and file a binding or whatever. So the judgment in Siemens of NCLT Chennai states to this effect that it will be taken from 25th of March, and any default occurring prior to 25th of March 2020 will not be covered under this amendment. So for that you can initiate proceedings. But despite the fact that the ordinance, the amendment came into effect on 5th of June 2020, the date of default will revert back, will go back to 25th of March because it is provided under the section. So post 25th of March, is if there has been a default, therefore there will be no initiation of no proceedings. But however, this issue will remain. How will the NCLT or any superior authority determine, if you go by the preamble, that this corporate debtor had the means to pay or it did not have the means to pay? The purpose was to protect those corporate debtors as per the preamble who, due to the unprecedented situation, are not able to pay. But now, if you read the section independent of the preamble, because once this gets incorporated into the act or the code, the preamble will vanish. Preamble is here today under the amendment. Once this section gets incorporated, which has got incorporated, the preamble will go. But nonetheless, you can read the preamble. So one difficulty is you are also under 10A protecting, as I read it, those corporate debtors which could have the means to pay, but who will also slip in under this 10A and say, see, we have no means to pay and the proceedings are suspended. Now the preamble says suspended, it says for some time. The proviso to the act says that no proceedings will ever be initiated. So how do you deal with this? What is the authoritative judgment on it? Is a financial creditor or an operational creditor barred from all times to come to file a section 7 or a 9? Or is it only for a period of 1 year or 6 months which is contemplated? So these are certain questions which arise. And as I said, it is an emerging law there are amendments coming now and then. It is a developing law. It is still at the very nascent stage. So there will be more pronouncements. So these are the essential amendments which have taken place. And
So is there any judgment by NCLT also on this? You mentioned NCLT Chennai.
to the best of my knowledge, this is before the NCLT. I don't think this has gone in an appeal before the NCLT.
All
But this is the only, as per me, as I saw it, this is the only authoritative announcement on Section 10A. But I am sure in the coming times, this will be carried on. This issue will be surely be debated before the appellate tribunal and the Supreme Court in some case or the other. Because there is an anomaly between the preamble and the section, and not on one account, on more than one account. So I would say it has been drafted in a perhaps in a very casual manner, but it will see some law being laid down on these provisions, and hopefully in respect of these issues which I was talking about. So these are the relaxations and the amendments which I wanted to cover. These are the material ones. There are amendments also in the regulations pertaining to liquidation. There are amendments in the regulations pertaining to the completion of the CIRP process. But these are all a fallout of the earlier relaxations which I told you. The amendments have been carried on, wherein the time frame for completion of stages in the liquidation proceedings or the stages set in the insolvency resolution proceedings under the relevant regulations of CIRP and liquidation regulations have been expanded. Obviously on account of COVID-19, but the amendments which I told you in respect of section 7, 14 and 32A, these are the amendments which were there prior to the COVID-19 pandemic. They are brought in by way of an ordinance under in 2019 and carried forward by way of an amended act in 2020.
Sir, thank you so much for enlightening us with your expertise on the subject. Over to you, Paritosh, for the vote of thanks.
Thank you so much, sir, for such a great session. It was quite informative. And thank you so much for taking out time from a busy schedule to enlighten us on such a expanding topic, which is yet discovering in the field of law. And I believe every lawyer or every participant who is watching this webinar at the moment should start getting into the subject and enhance it more.
Yes, I would surely suggest, recommend, and advise all the young budding lawyers, even the students who are aspiring to become lawyers, to take up this branch of law, because this branch of law is an ever expanding one, and the manner in which these amendments are being carried out, taking into account the practical difficulties or the practical situations or the changes which are going on today in the commercial arena, would give a lot of scope to the youngsters to practice there, to learn, and even to develop law. Now, let me at the fag end also tell you, see, I'll give you an example now. The case pertaining to the dispute between the telecom companies and the government, the AGR, adjusted gross revenue. The issue there was in relation to the inclusions in the definition of the term AGR. This was a case where the telecom companies had shifted from the license paying fee from that regime to the sharing regime with the government. Initially, these telecom companies were paying license on a fixed basis. Then they shifted over to the division of the revenues. So the dispute before the Supreme Court went on to the extent of seeing what all is included under the AGR. and whether the telecom companies are liable to pay for certain more services, which the government was saying are included in the definition of the AGR, and the telecom companies are saying it is not included in the definition of AGR. Now, while finally deciding this issue, I think last week, the Supreme Court has remanded the matter back to the NCLT.
Right.
Because the Supreme Court said that it involves an issue of jurisdiction, therefore it will go back to the NCLT. And please see the issues now which are to be decided by the NCLT. Is license fees which is to be paid an operational debt? Is license an asset under the IBC? Is spectrum again an asset liable to be transferred? See, look at the scope as to how the area of IBC is expanding. So it's an ever developing law, and it's something which I would advise all youngsters to go in, because there's so much to learn, and there's so much to argue, and there's so much of law to learn.
Right, sir. As you have covered almost everything that we need to look at, and it was a great session, sir. Can't thank you enough. And further, I would like to thank Mr. Jain Mudgal for getting you here and getting us an opportunity to get to know about this topic. And I would also like to thank Ms. Kopin Kandhari, Govind Chaturvedi, Janvi Sharma, Divyanshu on latest laws. This is Paritosh Dhawan signing off. Thank you so much, sir.
Thank you so much, sir.
So much for
Thank you, sir.